Good morning. Thank you for having me, organizing committee. Oren, Yechiel, Toda. Thank you for allowing me to also participate on your scientific committee. I've been privileged to read a lot of wonderful abstracts and papers, and I've learned from them. And I'm sorry, I just need to straighten out here. And thank you as well to many of my colleagues for mentioning Article 12 of the CRPD. Sagit Moore did a very good job of laying out some of the disability studies perspectives, and Professor Hughes did an enormous amount of heavy lifting this morning on some of the text of Article 12, and that'll free me up to give a different kind of talk, the sort of thing that you won't find written, but hopefully you'll find more interesting. Okay. Article 12, and just to be clear, I would never have the hubris to point to any parts of the CRPD where I might or might not have had an influence, but to be clear on Article 12, I resisted it at the UN in its formulation. I've critiqued it ever since. I've grappled with it both as an advocate, a practitioner, and as someone who's supervising at the moment about 10 PhDs, and 6 of them are focusing on Article 12. It has become, in some ways, a wonderful thing in that this neglected area is now exposed to the light, but in another way, it has become the obsession of many of the people and rising students in the disability rights community, many of whom grapple with what does this mean, because we honestly don't know what this means, despite the CRPD Committee's general comment number 1 interpreting it, and specifically, what does this mean in local context? What does it mean on the ground? What does it mean when you are a psychiatrist in the emergency room and someone is brought in a manic state, and guess what? They're not carrying an advance directive in their pocket, and they don't have advance directive instructions tattooed across their chest, and you don't know how to reach their family, if they do have family. If they have something called a circle of support, you have no clue what that is, because there you are staffing the midnight hours, and what do? And in the end, the short answer to that is something that several people, including Professor Hughes, mentioned, which is, you do your best under the circumstances to act in an ethical, prudent, caring manner. You try to be a mensch. But that you cannot legislate, and that you cannot put into a document, such as the CRPD. So Article 12 is, to give it a broad stroke, the most controversial article of this Human Rights Convention. Remember that this is a Human Rights Convention that has been ratified by 177 of the 193 UN states, excluding the United States, of course. So it is nearly universal. It is as close, we're coming up to being literally universal. And yet it is the most controversial. If we were to look at the reservations taken as against the convention, a reservation means the state says, well, I'm going to abide by the convention except for this part I have a problem with, or this part I don't quite understand yet, or this part I have a different interpretation of. I won't give you a law lecture on it. Nearly all of the reservations go to Article 12, with some countries saying we disagree with it, and some countries saying we don't quite understand it yet, but at some point we will, and at some countries saying we have a different way of viewing it. And so what we have in very broad strokes is a disability rights community being pushed by the psychosocial group, the users and survivors of psychiatry, and in some ways this is really wonderful justice. The people who claim to have been the most marginalized, not only from society, but from the disability rights community generally, taking the lead and making demands and pointing what it is that they say this article means. And then we've got the caregivers and the healthcare providers and others who are working day to day on the ground, not up here in theory, and not in law professor words, and not in in theoretical terms, but in day-to-day contact with users, and they're not talking to each other. They absolutely don't talk to each other, and that's some of what I'd like to focus on today. A bit of background in that I was very fortunate to have participated in the drafting of the convention. I have since then worked personally in over 42 countries on implementing various elements of the convention. I have, for better or worse, written more on the CRPD and on disability rights than anyone else. Whether it's any good is not for me to say. We have, through HPOD, Harvard Project on Disability, brought the landmark litigation around legal capacity to the European Court of Human Rights. Our intervention is the one that gets cited and lifted from the brief in Kish versus Hungary. We intervened for the first time at the UN at the CRPD and made them change their rules of procedure. The case was Bujdozo versus Hungary, a consolidated case of 6 relating to voting and legal capacity. I've spoken roughly 25 to 30 times a year in public for the last 15 years or so on the CRPD. So I have some perspective on it, but mostly what I learn on legal capacity is from speaking with psychiatrists, because I work with people in the medical profession, teaching bioethics, being on the UNESCO American Chair Board, and also having my wonderful PhD students from whom I learn and who try to figure out what does it mean, for example, I examined one last year, what does it mean if you're in Kenya and there are 300 psychiatrists in the entire country? What does it mean to have legal capacity or access to mental health? What does it mean to have supported decision-making when you're in the developing world and there is no Western medicine where you are? How do traditional caregivers respond to this challenge? And in reality, that's where we're going. That's where the research needs to be, because 80% of the world is the developing world. And so if we don't have the Western medicine, if we don't have the resources, if we don't have the ability to duplicate Sweden's Umbud, where they assign one person to an individual with an intellectual or psychosocial or mental health condition and get to know them and learn what their responses are, and then be actually able to do what the general comment number 1 says, and that is give the best interpretation of their interests. What if you don't have the resources to do what Sweden does, which most countries don't? How do you handle that? Is there also room, for example, to push back against the idea that forced interventions are always a bad thing? What I find troubling about General Comment 1 and about the CRPD approach is that it's absolutist. If you like, it's fundamental. It's fundamentalist. When we're given a text and told that there is only one interpretation of it, and that any interpretation that deviates from this interpretation is invalid, that is by definition a fundamentalist approach, whether it's law, religion, etc. So there is a pushback, by the way, towards that from the users themselves. Primarily, the research is now coming out of India. It was led for a little while by the Banyan. I'm sure you may or may not be familiar with that DPO, where women with mental health issues are picked up off the street. They're put into forced interventions. They're rehabilitated. They then live, if they like, on campus. They're referred to as fellows or guests. They can leave. And most of them, in the research that's coming out of it, when asked, what did you think about being forced off the street? What did you think about forced medical intervention? Will respond, well, I didn't like it at the time, but thank goodness you did it. Most of these women have been cast out by their families. They're subject to violence, rape, and other forms of abuse. So there is another part of the story. I'm not claiming that that is the dominant part of the story. I'm simply pointing out that there is not one simple picture and one monochrome view of what's going on. In any case, back at the UN, when we had the negotiations, Article 12, which went through several variations, the version that Professor Hughes put up on the board, noticed it had safeguards in it. Safeguards had to be enforced. The International Disability Caucus, led by an individual from the psychosocial movement, the users and survivors of psychiatry, actually objected to having safeguards in the article. Their view was, if you have safeguards, you are implicitly acknowledging that there may be a need for safeguards, ergo, you are leaving open the door to having people involuntarily committed, put under guardianship, substituted decision-making, etc. This was their logic. It ignored things like, the mental health rules from 1993. It ignored most of national law. They didn't quite win that. But their view of legal capacity, that everyone always has full legal capacity. Everyone always. I tell my kids, as well as what I tell my students, who in other ways are my kids, always, never, these are big words. These are big words. And if you throw up big words like that in front of any sort of half-decently logical person, we can come up with counterfactuals that pierce them. Do people in comas always have full decision-making ability? Honestly? Really? Do persons with extraordinarily low IQs, many of whom I work with, we focus at HPOD on people with intellectual disabilities, do they always have full capacity, even with support? Well, they can make decisions. Some of the people I work with, if you put in front of them a hamburger or a slice of pizza, they can gesture to one and not to the other, and certainly they're making their choice. They know if you like them or you don't like them. They know if you're speaking to them kindly or not kindly. Can they decide that they'd rather live in a group home of 4 rather than of 12? Do they know what stocks to invest in? Are they going to be good candidates for marriage, parenting, etc.? Perhaps. But can we say always, every time? That's a very, very difficult statement, but it's what the international disability movement pushed as far as Article 12. And they were not alone in it. They wanted to have everyone at the UN sign on to it. I was legal representative to at least 3 different delegations at the UN, and my advice was not to sign on to it, even though it was a lack of solidarity with the rest of the disability community. These were large disability organizations. With one of them, they went to the board and overruled the president, and not myself, because in my role as a lawyer, I give the best advice I can. And if the client wants to ignore it, so be it. That's my role as a lawyer. But Article 12 went in more or less the way that the disability community wished it. It was adopted in an interpretation by Louise Arbour, just as she was leaving the UN Office of the High Commissioner. If you read that interpretation, you will see that it is one of the sloppiest documents to come out of the UN, and that's a fairly high standard, to meet. Everyone always has interpretation. There is no such thing as a incapacity, or as they say, an insanity defense, and one of our colleagues spoke about that the other day. The criminal law, and not hospitals or the medical profession, should be the way to resolve violence among persons with various disabilities? Oh, really? So we don't, as governments or societies, have duties to protect innocent third parties from violence? We should let them be harmed and then intervene with the criminal law? Really? I never heard of that. Nothing about us without us, but it's the group of psychosocial disabilities who are speaking for persons with intellectual disabilities without consulting with them. Nothing about us without us, but what about people who may not even technically have disabilities? Someone who experienced trauma many, many years ago, and some act triggers a response that is violent and subject to the criminal law. We're going to speak for them without consulting them. And what about persons with dementia? And just elders in general? So that was one of the first iterations of it. Then the CRPD committee went ahead and drafted general comment number 1, and they posted it for comments, and they posted the comments online. I declined to put my comments online for the very reason that, given my reputation or whatever, any state that wanted to push back against general comment 1 could have pointed to my comments and said it was a legal opinion from me. So instead, I called up 2 members of the committee, because I always know the members of the committee, and people I know for a long time, and I had conversations individually with them. With committee member number 1, I pointed out some of the many flaws in the draft comment, and some of the problems with it. It wasn't legally, politically, or otherwise grounded in reality. And his response was, that's okay, because we're going to push the envelope. This is our chance as advocates to push the envelope and to cause what Professor Hughes referred to as a normative change. We can call it an expressive value or an attitudinal change. And I asked this person, well, wait a minute, but aren't you elected as an independent expert, something that Professor Bar-Ilan alluded to in his talk Sunday night? Isn't your duty to express what is and what should be, but not what you want it to be, and not to do it from politics, but rather from jurisprudence, expertise, etc.? And the response from this person was, well, we can always change it later on. Does anyone know of any instance in the history of the United Nations where there has been a rights-based anything that was later pulled back? I know of none. So anyway, that was one. So they revised it a little bit. They changed it. Notice, by the way, that the Human Rights Committee, which I'm very happy to say is now being led by Yuval Sheni. It's wonderful we have an Israeli to chair one of the treaty bodies at the UN. But not under his leadership, issued general comment number 35 in consultation with the committee and maintained that involuntary treatment, involuntary confinement under certain circumstances, proportional, etc., was valid. The CRPD committee was not happy about that, but nevertheless, it is what is. In response to this general comment, there have been several pushbacks. One was an article in the Lancet Psychiatry. It was written by 2 colleagues and several colleagues, but 2 prominently, Arthur Kleinman and Melvin Freeman, and they critiqued general comment number 1 from the point of view of healthcare providers. And some of their critiques were a little bit off. There should have been psychiatrists sitting there and working with the UN committee. That's not exactly right, because the experts are supposed to be on disability rights, although it raises an interesting question just generally. Wouldn't it be nice to have sociologists, psychologists, psychiatrists, economists, anthropologists, etc., sitting on these committees? It would be much, much deeper jurisprudence. But their point about there being no dialogue between the disability rights community and between the psychiatric treatment community was valid. How else are you supposed to get down on the ground and figure out what happens on a daily basis? Another implicit critique was the 2016 World Psychiatric Association Bill of Rights, which indicates that when the patient is incompetent to exercise proper judgment, psychiatrists should consult with the family and seek legal counsel to safeguard human dignity and legal rights. None of these sound very well with the international disability community, but they raise important questions that we need to know. So when we talk about supported decision-making, what do we mean? This is a question I often ask those who push forward on the polemics, not on the dynamics, but on the polemics of supported decision-making. And let me be clear about that. The dynamics are correct. We should not presume that people with disabilities, of whatever disabilities, are not competent, are incapable of making decisions. Most are capable of making decisions, and those who are put into places like institutions, isolated from others, just like any other muscle that you don't exercise, have lost the ability to make some decisions. So that's not what we mean. So the dynamic is right. Let's presume that people have capacity, and if they need support, we'll give it to them. And Israel, by the way, is one of the leaders in changing the guardianship law and putting in that notion of supported decision-making and just flipping the dynamic, changing the presumption. That's right. But what about in reality? What does this mean? Does it mean that we no longer have guardianship? Because guardianship has been one of the obsessions of the community. Guardianship exists in every country in the world. It's 2,000 years old. It goes back to Roman times, for better or worse. Do we no longer have guardianship as an institution? And if so, what do we have? And who implements it? Are we no longer going to have courts, family courts, probate courts, etc., who put people under and release people from guardianship? If so, what mechanism do we put in? Is a bad supported decision maker better than a good guardian? The Mexican Supreme Court, in another case that we intervened in, basically took the approach that we've got guardianship, let's reform it and make it so that we're supporting the people within the system rather than throwing out the entire system and starting from scratch. But that doesn't seem to be what most of the disability rights community wants. But in any case, is a bad supported decision maker better than a good guardian? I don't think so. What if a person with a disability rejects the advice of a supported decision maker or that of a guardian? What is the remedy? How does one challenge that, especially if one has been stripped of their legal capacity to raise and have standing to raise issues? What happens if there is a procedure to enable this person to challenge this decision? Who is it who intervenes then? Have the psychiatrists and the social workers and the psychologists all been magically disappeared? And is it now going to be a referee? A collection of persons with disabilities who determine whether someone is really bad at making financial decisions but is otherwise perfectly okay as far as deciding who to live with and where to live with? What are the mechanisms? These are not answered in the general comment, and it would be unfair to say that it should be prescribed to that level of detail in the general comment, but it's also not being answered even in hypothetical form by the disability rights community. There is, by the way, right now 17 countries on 6 continents that are piloting programs on supported decision-making, and we'll learn from that, but it's going to take a while to learn from that. And again, they all need to be culturally appropriate, resource appropriate, sociologically appropriate, and so forth. Do we go with advanced directives, which others have spoken of? Ulysses contracts, where you tie yourself to the mast, and no matter what happens, you do what I say now, but not what I say later. What happens if you turn up again in a crisis moment and you say, yes, I understand that I've said never put me in the psychiatric hospital, but I've just spent the night in a bipolar upswing and I've had sexual relations with people that I find abhorrent, and for goodness sake, don't let me go back out there, even if my advanced directive says never, ever, ever put me in the hospital. Or maybe it's the other way around. Maybe it's someone who says, yes, I understand when I'm in a manic state, I may spend lots of money, but I'd rather spend all my money than ever wake up in a psychiatric hospital. One could imagine that too. Psychiatric hospitals, of course, vary, and I've inspected institutions in various parts of the world. I can't say that any of them were particularly nice places. Some people were horrific places. Some people, and I say this as a child of a Shoah survivor, some places are reminiscent of those conditions. Some places are very civilized, as in Japan, where electroshock therapy is part of the routine admission process. We don't talk about that. I looked at 12 psychiatric hospitals around Tokyo. it's pretty standard. You bring someone in, you isolate them, you strap them down, you give them ECT, and then after about 48 hours, you decide what to do with them, but you don't provide them with legal counsel, you don't provide them with advocacy and so forth. So how do we figure this out? Well, I won't read you the results of it, and I'll keep us more or less on time. But Vikram Patel and myself, along with our shared PhD student, decided to do a little bit of research in this. And we did a global study with some purpose deviant sampling of people ranging from policymakers to psychiatrists to disabled persons organizations to users. And our results, just to give it to you in a few words, are that we did not speak to those who were at the ends, at the margins of this debate, the ones who are the most polemical. But they more or less, there is wide agreement that coercive treatment is heavily overused. There are questions around clinical validity of non-consensual treatment. Everyone more or less agrees that no country or law is fully CRPD compliant, and that there's a struggle between public health considerations and rights considerations. But then there was also a lot of discussion back and forth in these interviews about perceived reluctance among psychiatrists to relinquish power, the importance of building trust between the clinical community and the user and survivor movement, the dominance of discourse, and the way that the disability rights movement has had a very hegemonic view of how to do this. Some people within the community, within disability communities, see compromise as a betrayal of the rights that have been won. Some believe that compromise may be desirable, but is not a necessary condition for progress. And there is competing concerns that real life is not conducive to absolutes. So basically what we need is a safe space where individuals from different disciplines can come and discuss these issues and try to think about what the actual implications are on the ground and how to make it a reality. If we were to look at an equally, or at the time, an equally controversial element, I'm recalled going back 30 years, my law school dean, Jim Vorenberg, was suffering with Parkinson's, and he wanted to do something constructive. And so he pulled together a committee of 35 persons to talk about how you would draft a death with dignity law. Now, whether we believe in such things or don't believe in such things is not the point, but they had 35 people from different disciplines: social workers, lawyers, medical people, anthropologists, sociologists, economists, public health figures, and so on. And they came forward with their draft law and with a discussion of how they came about with it. Again, one can be for, against, or very worried about end-of-life decisions that way, but the idea of getting together a wide range of society, including the disability rights community, nothing about us without us, to actually discuss what to do on the ground and how to actually make this a reality, seems to be a mandate. Vikram and I are hoping to do some more work on this through the Global Mental Health Initiative that was launched at Harvard last year. And hopefully we'll be able to share some of those results over the next few years. So thank you for having me. I think